Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in McIntosh v. United States. In this case, the court considered this issue: may a district court enter a criminal forfeiture order when the time limit specified in the Federal Rules of Criminal Procedure has already passed? The case was decided on April 17, 2024. The Supreme Court held that a district court's failure to comply with Federal Rule of Criminal Procedure 32.2b(2)(b)'s requirement to enter a preliminary order imposing criminal forfeiture before sentencing does not bar a judge from ordering forfeiture at sentencing subject to harmless error principles on appellate review. Justice Sonia Sotomayor authored the unanimous opinion of the court. There are three types of time limits: jurisdictional deadlines, mandatory claim processing rules, and time-related directives. Jurisdictional deadlines completely deprive a court of power to act if missed, while mandatory claim processing rules regulate the timing of motions and claims, and if properly invoked, bar the relevant action after the deadline passes. Time-related directives, on the other hand, encourage prompt action but do not deprive an official of power to act if the deadline is missed. Rule 32.2b(2)(b) is a time-related directive for several reasons. First, the rule's language contemplates flexibility by allowing for exceptions when compliance is impractical, and using indeterminate language like sufficiently in advance. Second, unlike other parts of Rule 32.2, this provision does not specify a consequence for non-compliance. Third, the rule governs the conduct of the court, not the litigants, which is more characteristic of time-related directives than claim processing rules. Thus, a district court's failure to enter a preliminary forfeiture order before sentencing does not deprive it of the power to order forfeiture. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. In certain criminal cases, Congress has authorized the government to seek forfeiture of a defendant's ill-gotten gains as part of the defendant's sentence. Federal Rule of Criminal Procedure 32.2 sets forth specific procedures for imposing criminal forfeiture in such cases. In particular, Rule 32.2b(2)(b) provides that, unless doing so is impractical, a federal district court must enter the preliminary order of forfeiture sufficiently in advance of sentencing to allow the parties to suggest revisions or modifications before the order becomes final as to the defendant. The question presented in this case is whether a district court that fails to comply with Rule 32.2b(2)(b's requirement to enter a preliminary order before sentencing is powerless to order forfeiture against the defendant. In light of the rule's text and relevant precedents, this court holds that the failure to enter a preliminary order does not bar a judge from ordering forfeiture at sentencing subject to harmless error principles on appellate review. Between 2009 and 2011, Louis McIntosh committed a series of violent robberies and attempted robberies in New York. In one such robbery, McIntosh and two others held a man at gunpoint, bound and gagged him in his basement, and then took $70,000 in cash from the man's house. 5 days later, McIntosh bought a BMW for approximately $10,000 with cash and money orders, and listed his mother as the buyer. In June 2011, McIntosh was indicted along with 5 others on multiple counts of Hobbs Act robbery and firearm offenses. The indictment set forth that, for the Hobbs Act robbery counts, the defendants shall forfeit to the United States all property that constitutes or is derived from proceeds traceable to the commission of the offenses, including but not limited to a sum in United States currency representing the amount of proceeds obtained as a result of the offenses. The government provided McIntosh with a pretrial bill of particulars the next month that listed the BMW as property subject to forfeiture. A jury convicted McIntosh on all counts. On May 23, 2014, the district court held the sentencing hearing. The government had not mentioned the forfeiture in its sentencing memorandum, and the district court did not enter a preliminary order of forfeiture prior to the hearing. At the hearing, however, the government stated that it was seeking forfeiture for $75,000 in a money judgment, as well as the BMW. The government offered to submit a proposed order within the next week. McIntosh objected to the forfeiture. He argued that there was no dispositive evidence connecting the BMW to any robbery proceeds, insisting that a family member had purchased the car. It is not clear from the record whether McIntosh's objection to the forfeiture was also based on the absence of a preliminary order. The district court overruled McIntosh's objection to the forfeiture based on the trial evidence that the government presented. As part of the sentence, the district court imposed a forfeiture of $75,000 and the BMW as fruits of the crimes, and ordered the government to submit an order of forfeiture for signature by the court within a week. The written judgment memorialized these instructions. Notwithstanding the district court's order, the government failed to submit a proposed order of forfeiture. On appeal, the government moved for a limited remand to the district court to supplement the record by entering the formal order of forfeiture. The government conceded that McIntosh could then contest the timeliness of a formal forfeiture order, and the district court could make whatever findings it deemed appropriate. The Second Circuit granted the government's unopposed motion and remanded the case. Back in the district court, McIntosh objected to the government's newly proposed order. McIntosh argued that the district court failed to comply with Rule 32.2b when it did not enter a preliminary order prior to his original sentencing, and thus it could not proceed with forfeiture at all. In McIntosh's view, the delay prejudiced him because the BMW lost value while the forfeiture issue was litigated, which meant he would be credited less money against his money judgment. The district court again overruled McIntosh's objections. It concluded that Rule 32.2b is a time-related directive, rather than a jurisdictional deadline or a mandatory claim processing rule, and thus the court retained the power to order forfeiture. The failure to comply with the time-related directive, the court found, did not prejudice McIntosh. Accordingly, the district court entered the proposed order of forfeiture, and entered an amended judgment reflecting the order. The Second Circuit affirmed in relevant part. Like the district court, the Court of Appeals concluded that Rule 32.2b is a time-related directive, which does not deprive a judge of the power to take the action to which the deadline applies if the deadline is missed. The Second Circuit also rejected McIntosh's prejudice argument. In an accompanying summary order, the Second Circuit vacated the judgment in part and remanded for recalculation of the forfeiture amount because the $75,000 figure reflected the total proceeds of the robberies rather than the amount McIntosh personally received. McIntosh filed a petition for a writ of certiorari, alleging a split among the courts of appeals on the consequences of failing to adhere to Rule 32.2b's requirements. During the second remand, while the petition was pending, the district court entered an agreed-upon preliminary order of forfeiture for $28,000 and the BMW. On September 20, 2023, the district court entered its final forfeiture order. Days later, court granted McIntosh's petition limited to the question whether a district court may enter a criminal forfeiture order outside the time limitations set forth in Rule 32.2. Rule 32.2b provides, unless doing so is impractical, the court must enter the preliminary order of forfeiture sufficiently in advance of sentencing to allow the parties to suggest revisions or modifications before the order becomes final as to the defendant. The order becomes final either at sentencing or before then if the defendant consents. It is undisputed that the district court did not comply with Rule 32.2b when it failed to enter a preliminary order of forfeiture before McIntosh's initial sentencing. Despite that error, the district court retained its power to order forfeiture against McIntosh. This court has identified three types of time limits: 1. Jurisdictional deadlines, 2. Mandatory claim processing rules, and 3. Time-related directives. Jurisdictional deadlines are rare. If the court misses a jurisdictional deadline, it is completely powerless to take any relevant action, and the parties cannot waive the deadline. Put differently, non-compliance with a jurisdictional deadline cannot be excused. No one contends that Rule 32.2b is jurisdictional, because it does not expressly refer to subject matter jurisdiction or speak in jurisdictional terms. Instead, the parties' dispute revolves around the other two types of time limits. Mandatory claim processing rules regulate the timing of motions or claims brought before the court. That is why, generally speaking, filing deadlines are the quintessential claim processing rules. If the affected party alerts the court to the deadline and invokes its protection, the relevant action cannot be taken after the deadline has passed. Unlike jurisdictional limits, though, mandatory claim processing rules are subject to waiver and forfeiture by a litigant. Time-related directives seek speed by directing a judge or other public official to act by a certain time. Missing that kind of deadline does not deprive the official of the power to take the action to which the deadline applies. Moreover, whereas non-compliance with a mandatory claim processing rule is presumed to be prejudicial, the failure to follow a time-related directive is, in this context, subject to harmless-error principles on appellate review. McIntosh contends that Rule 32.2b is a mandatory claim processing rule, and thus the district court could not order forfeiture once McIntosh objected to the absence of a preliminary order prior to his initial sentencing. The government, on the other hand, argues that Rule 32.2b is a flexible time-related directive, and thus the absence of a preliminary order did not bar the district court from ordering forfeiture at sentencing. This court agrees with the Second Circuit and the government that Rule 32.2b establishes a time-related directive. Accordingly, a district judge's failure to enter a preliminary order prior to sentencing does not deprive a judge of the power to order forfeiture. In Dolan v. United States, this court similarly addressed the proper remedy. for when a district court misses a deadline to take action related to criminal sentencing. That case involved a provision in the Mandatory Victims Restitution Act of 1996, which states that, if the victim's losses are not ascertainable by the date that is 10 days prior to sentencing, the court shall set a date for the final determination of the victim's losses, not to exceed 90 days after sentencing. This court noted that the statute did not specify a consequence for non-compliance with the deadline. It then held that the provision was a time-related directive, such that, if a sentencing court misses the statute's 90-day deadline, even through its own fault or that of the government, the sentencing court retains the power to order restitution in that circumstance. Dolan was just the latest in a line of cases recognizing that certain deadlines, if missed, do not deprive a public official of the power to take the action to which the deadline applies. Each of these cases involved timing provisions that did not specify a consequence for the public official's missed deadlines. In such circumstances, courts will not in the ordinary course impose their own coercive sanction, nor typically attribute intent to limit an official's power to get a mandatory job done merely from a specification to act by a certain time. In this court's taxonomy of time limits, Rule 32.2b, 2b, is best understood as a time-related directive. It functions as a spur to prompt action, not as a bar to tardy completion of business. Several features of the rule guide this court's analysis. First, far from imposing rigid constraints characteristic of mandatory claim processing rules, the plain language of the rule contemplates flexibility regarding the timing of a preliminary order's entry. It requires that a preliminary order of forfeiture be entered before sentencing, unless doing so is impractical. As such, the rule anticipates that, in some circumstances, it may be impractical to enter a preliminary order of forfeiture before sentencing. Similarly, rule contains the indeterminate command that a preliminary order be entered sufficiently in advance of sentencing to allow the parties to suggest revisions or modifications before the order becomes final as to the defendant. Of course, what is sufficient in one case may not be in another. Both the impracticality exception and the sufficiently in advance condition take the rule further away from the category of rigid and inflexible claim processing rules. Second, Rule 32.2b, 2b, does not specify a consequence for noncompliance with its timing provisions. In the absence of such specification, courts will not in the ordinary course impose their own coercive sanction for noncompliance with a timing directive. Indeed, it would be especially strange to prohibit a sentencing court from ordering forfeiture for not complying with Rule 32.2b. 2b where other parts of Rule 32.2 specify that consequence for noncompliance. Rule 32.2a, for example, provides that the government's failure to include a forfeiture allegation in the indictment means that the court must not enter a judgment of forfeiture. The use of explicit language specifying a sanction in Rule 32.2a but not in Rule 32.2b. 2b cautions against inferring the same limitation in Rule 32.2b. 2b. Third, Rule 32.2b. 2b governs the conduct of the district court, not the litigants. Recall that time-related directives typically spur public officials to act within a specified time. Mandatory claim processing rules, by contrast, ordinarily require that the parties take certain procedural steps at certain specified times. That distinction holds even in the examples that McIntosh identified of claim processing rules addressed to courts. Take Santos, Zachariah, and Gonzalez, for example. The claim processing rules in those cases condition the court's authority to act on the parties' adherence to a certain procedure, and not on the court's compliance with a deadline. McIntosh has not identified a mandatory claim processing rule that is analogous to Rule 32.2b, 2b. In sum, Rule 32.2b, 2b is a time-related directive that, if missed, does not deprive the judge of her power to order forfeiture against the defendant. McIntosh's arguments to the contrary are unpersuasive. He first points to Rule 32.2b, 2b's use of the word must to highlight its mandatory character. Yet this kind of mandatory language standing alone has not always led this court to interpret statutes to bar judges or other officials from taking action to which a missed statutory deadline refers. Additionally, Rule 32.2b, 2b's use of must has to be construed in context to determine whether its time limit is a mandatory claim processing rule or a time-related directive. That context, as discussed above, demonstrates that the rule contemplates some flexibility by specifying that the preliminary order be entered sufficiently in advance of sentencing, unless doing so is impractical. McIntosh also argues that it makes sense to classify Rule 32.2b, 2b, as a mandatory claim processing rule because Rule 32.2 requires the government to take specific steps to move the criminal forfeiture process forward. For example, the government must provide notice in the indictment that it will seek the forfeiture of property as part of any sentence, establish the requisite nexus between the property and the offense, and publish and send notice of the forfeiture order to potential claimants. Although McIntosh is correct that the government plays an indispensable role in the criminal forfeiture process, Rule 32.2b is directed exclusively to the sentencing court. It does not even mention the government. That the instruction to the court may in turn push the government to take certain steps as a practical matter does not change the rule's addressee. McIntosh further contends that an affirmance here would deprive Rule 32.2b of any effect such that it might as well not exist. Not so? In most cases, a timely objection required to preserve a claim of error likely will prompt the district court to enter the preliminary order and, if appropriate, postpone sentencing. As counsel for McIntosh conceded at argument, defendants receive the benefit of the rule in that situation. If a timely objection is raised and no preliminary order is entered, at the very least, the violation of Rule 32.2b would be reviewed for harmlessness. Finally, McIntosh falls back on the general purpose of Rule 32.2, which he describes as ensuring criminal defendants receive due process before their property is permanently taken by the government, and promoting judicial economy. That is all true. McIntosh does not explain, though, how it promotes judicial economy to treat Rule 32.2b as an inflexible claim processing rule. If anything, judicial economy is better served by allowing courts some flexibility to ensure the accuracy and completeness of the final forfeiture order, and address an inadvertent failure to enter a preliminary order in advance of sentencing. Because McIntosh has not shown that reading the requirement as a time-related directive would significantly frustrate Rule 32.2's effectiveness, McIntosh's invocation of purpose falls flat. Non-compliance with Rule 32.2b's timing requirement is a procedural error, subject to harmlessness review. Here, the Second Circuit agreed with the district court that McIntosh failed to show prejudice sufficient to void the forfeiture order. Both courts noted McIntosh knew from the time of his indictment in 2011, and from the pre-trial bill of particulars, that the government sought forfeiture. Both courts also rejected the argument that the absence of a timely preliminary order prejudiced McIntosh by causing the BMW to lose value. They explained that McIntosh could have sought an interlocutory sale of the car if he had wished to preserve its value, and could have done so without a preliminary order. McIntosh did not challenge the lower court's harmlessness analysis in either his certiorari petition or his opening brief, so this court need not revisit it. Because Rule 32.2b is a time-related directive that, if missed, does not deprive a district court of its power to order forfeiture, the judgment of the Court of Appeals for the Second Circuit is affirmed. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.